everybody. It's 8:30 here. Mr. Drew and myself come to give you a little update about our gun cases. It's been a week or two. We had a few things going on worthy of talking about. As you can see, I'm sitting in my office with my t-shirt on, and my esteemed colleague, Mr. Drew, got a suit. He always got that suit. A sharp-dressed man. So appreciate him taking the time out of his busy schedule to join in. It's always, his perspective always is well received. So a couple of things to point out. As you guys are aware that the Macon County case, last time we talked about it, there was a final order entered in that case that the gun ban is unconstitutional because of equal protection, because our case had ruled that at the appellate court level prior. So the Macon County case has now been, the governor filed his appeal within 2 hours. I think that was a world record after the judge entered that order. Yeah. Now, what you need to know is that the judge ruled that the law was unconstitutional for equal protection. The judge did not rule, and he could not rule, that there was a violation of the procedural issues for the three readings clause. Only the Supreme Court can make that ruling. But it's worth noting to you that Dan Calkins did not appeal that issue to the Supreme Court. They chose not to even make that argument, which is a huge, huge fatal flaw. And we'll get to it in a second on why that's a problem. So the only issue in that Macon County case that's pending in front of the Supreme Court is the equal protection issue and not the procedural three readings issue. And they're now going to be arguing just the one issue. I think on March 20th, so what, 2 or 3 days ago, the governor's office filed their brief with the Supreme Court in that Macon County case. It's 107 pages long. It's very detailed, it's very thorough, and they make the arguments on why the Supreme Court should find that the law is constitutional. I am going to wait and see, and I look forward to hearing what Mr. Drew has to say on how thorough of a response that the Dan Calkins and his lawyer will prepare and file in that case, because as of yet, their efforts have been limited to copying and pasting the work that we have done for you. So in order to make the arguments that need to be made, which again, have issues because they don't have any facts, and we'll talk about that in a second, they still got a lot of work to cut out for them to file a response to that 107-page argument. So I'm really hopeful that they'll find it in them to do the work that needs to be done in their case to make the best arguments they can make. But it's going to take, I don't know, Brian will have his own opinion. It'll take couple, 200-300 hours to do the research that needs to be done and the analysis that needs to be done and the planning of being able to prepare their own responsive brief. You got any thoughts on that, Brian?
Oh, it'll take every bit of that. I mean, you've been working on this now for weeks prior to the complaint you filed originally, and now that's a few months ago. I mean, I get back and forth. I get documents from him. Hey, okay, check this out. This is where I'm going here. And it's nonstop. I mean, you live this day in and day out. I mean, it's what you do every day, all day long. I've read a lot of briefs. I've dealt with a lot of people. No one knows it better than you do. And the frustrating part is they kind of jumped in on this at the end. And I'm very fearful that they're not going to flush it out, because as you go through, which I've been through the 107 pages of the state's appeal, and they bring up a lot of deficiencies in the case that I don't think Calkins and his attorney ever considered. And that's the frustrating part, to see that. And, what was the one document he filed was it a few lines? Was it a couple pages?
Well, one of them they filed was actually 2 paragraphs.
Yeah,
it was about a third of a page. But
I mean, these are very detailed, very complex issues that require some pretty in-depth research work, and like you said, hundreds of hours. So, I don't think the best case is going to be getting there to the Supreme Court right there. But I think you've talked about that we may try to do an amicus brief to try to bolster them up and help them out, So that way, you know, maybe a little better argument can be placed out there.
Well, Benjamin just kind of said that. How can we help him win? Let's be clear. I'm not going to help Dan Calkins do anything. He is on his own. But to the extent that we can file what's called an amicus brief in that Macon County case, where we can make legal arguments on behalf of our clients, on behalf of people of Illinois, independently of whatever they do. And Brian and I have talked about doing that, and we likely will do that. But, you know, ultimately it's their case. I mean, they're the ones that wanted to be the big shots and run to the Supreme Court. Now, again, the time has come to where you can't just steal other people's work. And when I use the word steal, I'm not using that inappropriately, because you can go copy and paste anybody's work out of the court record that you want to. That's not inappropriate. But when you go and grab somebody else's legal work, but then you can't do that anymore, then eventually you got to do your own work. And that's kind of where they're at. So, you know, can we try to file an amicus brief in that Macon County case? Yes. Will we? Certainly. But, you know, it's going to be us doing the work for them again, which is a little frustrating, but we'll do it because it'll benefit our clients. So we'll deal with that. But in the meantime, now let's talk about our case, the Effingham County case, which all of them have been brought into one, you know, so we call it the Effingham County case. After the Supreme Court didn't consolidate our case into the Calkins case. See, when we asked the Supreme Court to consolidate all of the cases together, it included the Macon County case, and the governor and the attorney general and Calkins, they all said, oh, no, don't consolidate the cases because they're so different that it doesn't make sense to consolidate them. There's nothing to gain by the consolidation. What they were really trying to accomplish is to keep Dan out on his own so they could play the games they wanted to play, because if we were all in the same case, Brian and I would not have let that happen. So now that case is at the Supreme Court, in our case, the governor and the attorney general and the Speaker of the House, all of the defendants filed two things. They filed a motion to stay our case, which what that means is to stop it. Don't let it proceed any further until the Macon County case is resolved. You understand what I'm saying there? They want to say, oh, put it on hold. The other thing that they want to do is they want to stop us from undertaking discovery. We can't ask them any questions. We can't ask for any documents. We'll get to that in a second. So yesterday, I think it was the 21st. Yeah, yesterday we had an argument in the Effingham County Court on their request to stay our case, to put a hold on it. And what they argued is that these cases are so similar to the Macon County case. It's kind of odd now that they're arguing that they're so similar, that our case should be stayed, and we have to wait and see what happens in the case up in the Supreme Court in Macon County before our case proceeds. It just makes sense to do that. And again, that's kind of what they argued in a nutshell. And we argued, said, well, if they're so similar, why didn't you agree to consolidate them all together? It was kind of funny. And I told the judge, I said, obviously the Supreme Court of Illinois didn't think they were that similar, or they would have consolidated them together. And I told the judge, really what this is all about is them trying to stop our case from proceeding because they don't want to answer the questions that we're asking. They want to hide from us, hoping that they can win in the Supreme Court against Dan and keep from ever having to answer our questions. That's what I argued to the judge in a nutshell. And the judge agreed with us. The judge said these cases are not the same. He specifically said, judge did, is that the Macon County, the Calkins case, didn't do any discovery. And the judge was clear in his answers that he believes that discovery is important. And so he denied their request to stay, and our case will proceed. Okay? That's an important thing for you to know. Our case continues. Now we have the issue of discovery, of what discovery that we're going to be allowed to engage in. Yesterday, we dealt quickly with a couple of subpoenas that we had issued to the Illinois Sheriff's Association and the Illinois Association of Police Chiefs. There were two reasons that they argued. The real reason is they just don't want to give us the information because they don't like probably what it's going to say. But they argued procedurally, well, this date that Tom gave wasn't enough time, and the date wasn't right, and we think that we shouldn't have to answer that. And all Judge said is, Tom, just fix that stuff and resend it to him. And I'm like, okay, Judge, I'll do that. So when you read in the record, the judge quashed 2 subpoenas, it doesn't mean anything. It just means the judge said, fix those dates and resend it to him. And I said, that's fine, Judge. I'll fix the dates and I'll send it to him. So it's nothing. But still, we have the issue, the bigger issue on discovery, which is the governor and all of these bureaucrats and these associations are trying to argue to the court, and we haven't argued it yet. We argue it on May 4th. They shouldn't have to give us any of these documents because it's privileged. It's hilarious. They have legislative immunity and they don't have to give us any of these documents. I think you can reasonably infer from the judge saying that discovery is important, that he likely believes that they're going to have to turn this over. But I'm not going to assume what Judge Jarman's going to do until he makes his decision. But it seemed clear to me that he thought he was going to let our case proceed because discovery, he said, Calkins didn't do any, and that he thinks it's necessary. So it would seem to reason he's going to let the discovery happen, but they still have a right to argue that they don't want to give us anything. And so on May 4th, we'll argue where they think it's privileged. But I want you to think about that for a second. Here's your legislature, your Democratic legislature, who is not doing anything in public. There's nothing happening on the House floor or on the Senate floor. There's no debate. There's nothing, because they do it like thieves in the night at 3 o'clock in the morning. They send backdoor text messages and emails to all of their buddies, and that's how they legislate. And now they're trying to argue, and in my humble opinion, they'll be unsuccessful. Brian will have his opinion. They're trying to argue, but you, public, you can't have access to any of that. That's privileged. That's for us, and you can't see it. And I'm almost trying to keep a straight face yesterday when they were making those arguments that, no, you can't do that. They do have some types of immunity. It's very limited, where you can't sue them for damages. You can't sue, they can't be charged criminally for their legislative work if it's legitimate legislative work. If they're talking on the House floor or on the Senate floor, if they're speaking during open session, I can't ask them questions about that because guess what? It's in the public record and I have access to this information. But their backdoor stuff that they're doing, their private text messages and emails, and guess what? I asked them for studies, which I'll get to in a second. That's not privileged. It's absolutely ridiculous to argue that it's privileged. But they're so desperately looking to try to keep us from getting this information that they're going to fight and kick and scream like a bunch of petulant kids until they can't fight and kick and scream anymore. That's what they're doing. And it's ridiculous. Go ahead. You got anything to add, Brian?
No, I mean, a little bit, yes. I think you're exactly right. I mean, they're going to get down to the procedural stuff. We'll take care of that. That's not a big ticket item. But now they're down to the substantive fight, which is simply, and it's exactly what you said, which is, once again, I have heard arguments in this case on behalf of the government, the likes of which are still shocking to me. I mean, the one argument of, yeah, we violated the Constitution with a 3 readings rule. And by the way, there's nothing you can do about it. That was the first one. And this is the second one. Yes, we have no legislative record whatsoever. We never discussed this bill in any way. And so when did they discuss it? When did they come up with the language for it? How did they come up with exactly how to do several dozens of...
Brian, let me interrupt you for a second. There's somebody over here chiming in. They think they're smart, and they're probably, their IQ is about 50, talking about how, oh, I'm sure that the government's watching this video and they're taking notes and they're going to learn what you guys are up to. People, it's no secret. We're talking, there's no secrets in a courtroom. What we're trying to accomplish and what the government's trying to accomplish, we all know it as lawyers. We understand it. So there's no KFC secret recipe that Brian and I are talking about that the other side doesn't already know, you guys. It's not how the court system works. So quit watching Law and Order and trying to think that you know what lawyers do. Unless you're a lawyer, you don't understand this stuff. So don't be doing that nonsense. I apologize, Brian. Go ahead.
Oh, no. I mean, and on that note, it's true. These things, that's what discovery is about. So that everybody's supposed to know everything about everyone. And that's why they're fighting so hard, because they don't want us to know everything about that they have. And, this argument of, well, we have absolutely no legislative record. We never discussed it. Well, how did they put together the dozens of pages that made up this bill? How did they come up with the exceptions? How did they come up with the exemptions that aren't in it? When did they do this? Because there's nothing in the legislative record. They did it all behind closed doors. They did it all secretly. And now we say, well, we want to know how you came up with this. And their answer is well, we don't have to, because we have privilege and you can't ask us about it, which is, I mean, I can't think of anything more undemocratic than for legislators to say, yeah, we passed a bill that greatly affects your constitutional rights, and you're not entitled to know why we did it or how we did it or what we even discussed while we did it. I just can't fathom that that's their defense at this point in time. And I think it's why this case we have is so important for everyone. And the 3 readings rule and these procedural things, I know that gets very boring. And I understand it. Tom and I get excited about it, but we're lawyers, and so we're kind of weird, and we get excited about things that nobody else would get excited about. But the reason that is because it really could, if the Supreme Court did what I think they ought to do and what Tom thinks they ought to do, which is stop this and make them accountable to the people the way they should be accountable. It could legitimately alter things where they can do this no more. Everything they do will have to be out in the open. They'll have to discuss it. They'll have to have these conversations. And if they don't, none of their laws will be valid. It could fundamentally change the way things are done in Illinois. And I think it's long overdue. I mean, with decades of corruption, I mean, at some point it's got to stop. So.
Well, obviously, we are doing this through the courts. The only chance we got to stop it, because the way to stop it otherwise is for people to unelect these bums. But obviously, that's not going to happen. Look at our last. I'm going to complain a little bit, Brian. Look at our last election cycle in 2022. The voting turnout was horrific. It was deplorable. But people want to whine and complain about how government's doing them wrong. But what? 40% of the people turn out to vote. So the court's the only way we have to fight this thing still, because we can't fight it through elections because people don't care enough to get off the couch and go vote. That's unfortunate, but it's true. So let me give you an example of why they're fighting us so hard on the discovery, you guys. Okay. Some of the questions that we asked in our discovery of the governor and of the legislators was of studies, of data, of reports that support a variety of different things. And one of them was to support the proposition that these guns, these, we'll call them assault weapons, are part of trafficking of weapons. They're used in crimes, etc. Show us the data that these weapons are so bad that you need to restrict them. And we all know about the Highland Park tragedy. We get it. We understand that. But the Highland Park tragedy in and of itself being one tragedy, they didn't try to say they passed this law because of one tragedy. That's probably true why they tried to pass it, but they couldn't get away with that. They have to say that it's based upon, a chronic use of these types of weapons in trafficking and crimes, etc. You with me? We asked them for any data or studies that would bolster and support that proposition. Are you with me? So we asked for that at the end of January, beginning of February, maybe the beginning of February. We asked the governor for those studies and data and reports. Are you with me? And now Ryan put up on the screen what the Illinois State Police sent to the governor's office. And I guarantee you they sent this in response to what we asked for. Look right here. There was a law passed in 2019 that dealt with gun trafficking, you guys, and it mandated that the Illinois State Police start keeping track of a lot of different information, look, related to firearms used in the commission of crimes in Illinois. Do you see that right there? That's what this law required them to do 4 years ago. Scroll down, Ryan, show them where the part's at. This is the Illinois State Police in February 20th. Keep going, right there. Oh, go back. Right there. Since January of 2019, the Illinois State Police has been unable to identify a comprehensive data collection tool capable of the detailed data capture mandated by the Illinois Gun Trafficking Information Act. What they just admitted right there to you guys is that they don't have, nor have they even implemented any of the reporting that they say they were relying upon in part to pass this law. You understand what I'm saying? That's why they're fighting so hard for not answer our questions, is because we're going to be able to prove that all of this smoke and mirrors that they're throwing out there is bullshit. That's what we're going to be able to prove, and they don't want us to be able to do that. They want to go into the Supreme Court and talk about, oh, we had to pass this law because of all the crimes that are committed with these weapons, all the gun trafficking that happens with these weapons. They don't even freaking know the answers to those questions, because right here, the Illinois State Police has admitted in a letter to the governor after we asked for it. Brian and I asked for it. And they're saying and admitting to the governor, we don't have it. You see what's going on, you guys? And when was that sent? February 20th, 2023. A month ago, while your case is pending. And we asked for this stuff, and they're now acknowledging, guys, they do not have it.
And you know what, Tom?
Go ahead, Brian, your turn.
The other thing that's even more striking about that is that means since 2019, when the legislature enacted this law and told the Illinois State Police, you have to keep all this. Now, mind you, typical legislature acts in Illinois, they don't fund it. They don't tell them how to do it. They don't provide any software or anything to do it to the Illinois State Police. Just tell them, like every other thing, an unfunded mandate, go do this. But we're not going to fund it or help you in any way do it. We're just going to tell you to do it so we can go tell all the people to vote, look what we did when they did absolutely nothing. I mean, that's common in Illinois. So now the state, but what that really means, and the key there is, not only has the Illinois State Police said, look, we've tried. We cannot keep this data. We don't have it. That means no one from J.B. Pritzker to the legislature to the Attorney General Kwame Raoul himself have ever bothered since 2019 when they entered that law. No one's ever bothered to go to the Illinois State Police and say, hey, where's this information? Where's the data about weapons being used in crimes? Where's the data at that we told you had to keep in 19? For the first time ever in 23, when you and I file a lawsuit, you and I ask for discovery and we say, hey, where's these studies at you mandated them to have? For the first time, the governor, the attorney general, and the legislature went, oh gosh, I guess maybe we should ask. And they asked for the first time, and their letter back was, oh, by the way, for the last 4 years, we haven't been able to do anything.
But yet they told the people of Illinois that these were the studies and data they were relying upon when they passed this damn law.
Yeah, and that's what they said, which means it's just not true. There's nothing.
You can't make this shit up. You can't make it up.
Obviously, no one even asked the Illinois State Police for this information for 4 years. And yet they say they're worried about crime and they're worried about gun violence. No, they're not. They're worried about getting reelected. And what they do is they pass these laws. They don't fund them. They don't even check on them. They don't care. They pass them, throw out the press release, wave to everybody, take their votes, get elected, and move on to the next election. I mean, it's just, and you know what's bad is, you might actually be able to figure out how to put an effective strategy together to try to help some of this gun violence. If they had these numbers, but they didn't care. 4 years they ignored it. And for the first time ever, we asked them, and now they went, oh gosh, uh-oh. And you watch, they're going to try to brush this under the rug every way they can, that they never even asked the Illinois State Police for these numbers. It's just shocking, the incompetence that goes on and just the lack of caring.
And that is just the tip of the iceberg
yeah.
of what our discovery information would uncover with all of this. Tip of the iceberg of it. And that's why they are fighting and fighting. They probably, Brian, and you said it best, our Illinois government is probably hoping that the Supreme Court finds the gun law unconstitutional, because it would get them out of having us uncover the fact that there is incompetence at all levels and they don't do any of this crap.
Oh, I mean, at this point in time, they, the worst case scenario for them is they win at the Supreme Court with Calkins's case, because that means our case moves back to the front, and now all the discovery is going to be answered. The case is moving forward, and they're going to have to answer all these questions. And it's not an accident. They're fighting harder to keep from answering our discovery than that 107-page brief that they filed to try to keep the law constitutional pales in comparison to the amount of time, effort, and money they've spent to keep from answering the questions we've asked.
Oh, you're damn right. The risks that we pull all this information and lay out how this law was passed inappropriately, how they violated the constitutional procedurals, and expose the Democrats for what they are. That's what they care about. Yeah. This gun law, yeah, it's important to them, but they'll lose the gun law case in a heartbeat if they can keep us from taking them out on their procedural constitutional violations. That's what they can't afford to lose, because it'll alter how laws are made in Illinois for generations, and they don't want to give that up. They can't give that up, and they're more, you're right, Brian, they're more concerned about that than they are the rest of it. That's why when Dan Calkins decided to be their patsy, ignorantly or otherwise, they were elated, and it took a load of pressure off of them, because that was the only chance they had to get out from under any of this. It's a small chance for them, but it's still possible. Yeah, they're looking to get out from under this at all costs. So when the judge didn't stay our case, I guarantee you that's got them a little bit nervous, because they're eventually, absent something we can't see right now, they're going to have to answer this discovery, and it's going to show. They didn't have any studies to rely upon. They didn't have any data to support any of this. They didn't have any of it. I guarantee you they didn't have any of it. And when we can show the people of Illinois and the court that they didn't have any of that, then maybe something will change.
I saw a comment on here, which is actually a pretty astute comment, where they talked about Calkins's case, and they said that, the equal standing. And I think someone's actually gone through and read the brief there, which kudos to you for doing that. That's not being an attorney and reading those pages. I got it.
You find it, Brian?
Yeah, my connection got off there.
It's yours. It's not mine.
It is. My connection that time a little bit. It never fails. So what it was about the equal footing, and the state's arguing in the Calkins case, look, they are unnamed plaintiffs. They're this association, and you haven't alleged any individuals where you can remotely now argue that they're at the same level footing as the people who got the exceptions. And that's a difficult thing, that the Calkins case, because they didn't do any discovery, because they fast tracked this and tried to run up there quick and pulled this association together instead of individual plaintiffs like you and Ryan did. I can't fathom how many hours you guys had to spend to get all these thousands of people listed in a complaint. I didn't even want to begin to think about how long that took. But instead of spending all that time and effort to do it, they fast tracked it. And what they've done now is they are going to have one heck of a time, because you can't make up plaintiffs and make up scenarios and say, oh, well, these people are in the same stead as the individuals who got the exemption, who are allowed to continue to use and have assault weapons. You can't make it up. You have to have actual people and examples of it in your case. And now they don't have that. Now, we're going to do everything we can and hope they win. We're not rooting against them. It's just There's all these problems that is so frustrating, because it makes our job harder. It harms the case, and it runs it up there and allows them to file the motion, like to stay our case. And we're going to get another motion before long. Once the Supreme Court rules, we're going to get another motion from the AG's office and the governor saying, well, now their case needs to stop for one reason or the other. And you and I are going to have to spend, well, you particularly, hours and hours fighting that motion. We're spending a lot of time fighting against motions we shouldn't have to be fighting against. We all should be working together. And that's probably the one thing that is most frustrating. So But for our case, we're moving forward. Do you want to explain to them? A couple people asked what an amicus brief is. I don't know if you want to talk about that.
Go ahead.
I mean, in essence, what it says is that if you have a particular reason that you believe that your opinion or your argument should be heard by the Supreme Court by way of a written document, you do not get to orally argue it at the Supreme Court. You can request leave to file an amicus brief, which is basically just a brief in support that says, I have clients, in this case, a large number of people, thousands, that this case could potentially affect. And in turn, we want our clients' arguments presented there. Now, we can only go on the evidence and the facts and the posture of the case that Calkins' case has at the time. We can't bring in new facts. We can't bring in new evidence. We can't do anything else in his case. All we can do is to maybe try to flush out the legal issues about the standard of review that the case should use and some of these other things so we can get that done.
Daniel asked about, do we need similarly situated people to testify later? No, nobody has to testify. We may do some affidavits of people that have concealed carry, et cetera, to show what the training is, but we can get to that down the road. Right now, we're really speculating on the training issue where they say, oh, we exempted these. When we filed this case, we had no idea why they exempted out 7 categories of people, right? So to argue that we were similarly, and Judge in our White County case, he made it clear. How could we have possibly argued in our pleadings that our clients were similarly situated to the classification of exempt people? We don't even know why they're exempt. And today we still don't have any facts that argue why they're exempt. It's just a lawyer trying to say it's based on training. So, but we may do some affidavits and stuff. We'll get to that. But right now we're just trying to get to the discovery phase. Good. Did you get locked up again, Brian? You still there?
Yeah, just a little bit there. Sorry about that. Yeah.
Okay.
No,
I mean, do we have anything else that we haven't covered? I mean, we got a hearing on May 4th where we'll deal with them trying to say that they have immunity from giving us the documents. I don't see the judge buying that argument, but again, I don't want to ever presume what a judge might do. But they're going to just keep trying to delay our discovery requests. You know, and they're going to look for every little way they can to kick and scream and, again, fight like a bunch of crybaby kids because they don't want to give us that stuff or the lack thereof because it's going to expose them and make our case even stronger. Not only does it make our case stronger, which is what we care about, it even on a more broader scale shows that they're just a bunch of, you know, politicians and they say crap that's not true. I mean, again, they've told you they passed. Governor Pritzker said, oh, we passed this law because of, remember the facts and science that he's been pontificating about for years now? There's no such thing as, even in the COVID, there was no facts and science, you guys. It was all bullshit. There was no facts and science, just like now. There's no facts and science. There's politics. The governor was looking to exploit a political issue like weapons for his own brand because he wants to run for office at a higher level. That's the only reason he did this. And he talked about all the data and the studies. They don't have any of that crap. And we're the ones asking for it, right? They're not asking for it in the federal cases. The governor never saw these state court cases coming. The governor and all of them thought that we'd be fighting in the federal court about highbrow Second Amendment, which is good stuff. And we may go there. But these issues that we're raising in the state court, they never saw any of that coming. It caught them off guard. And they just, you know, now they're scrambling to try to keep from having to, you know, answer the real questions.
Oh, and that's exactly right. I mean, that's the key to the thing. They really thought everyone would only be in federal court arguing the Second Amendment, which is, like you said, very, very important. They never dreamed someone was going to call them out on the 3 readings rule, was going to get into the fact that they didn't do any legislation. They didn't do any discussion at all. They have no studies. I mean, it's just, there's every single thing that we get. And if you notice, the state police has come out and put this letter out. I mean, they're clearly saying, look, this isn't our fault. They told us to do it and it wasn't possible. I mean, there is a lot of people in Springfield right now scrambling because for the first time, some people have said, hey, we want to know what's going on there. You're going to tell us what's going on there. And we're not stopping until you do. And I think that's why we see the fight they're having. But Our case is going well. I mean, we're going to have a hearing about the motion about whether or not to get the discovery. I think we have great arguments to put forward for the judge to rule in our favor, to say there is no privilege for this. You're going to provide all the documents. You're going to provide the information. You're going to answer the questions. And once we get that, I really think we'll be able to put a case together to show that some of our concealed carry members that are in our case, some of our people who are retired military, that these people are equally trained or better trained than the individuals that the state of Illinois exempted out for no reason other than possibly political reasons, or I don't know why, but it isn't for the reasons they've stated. And once we get those people on an equal footing, we'll have the evidence to show that. And when that happens, I think equal protection grounds, this case goes down, and we're going to, and I think if the Supreme Court does what I hope they do, is put an end to the violation of the Constitution by the Speaker of the House and the President of the Senate, then not only will this law get thrown out, but will also alter the way government's done. And I think with this information that we're pushing for, I think we can get it done.
Tom Keene just said the longer this drags out, you'll need to ask for more funding. That's not true. People that hired us to do this job, they paid a flat fee. That's all it's ever going to be. And if it drags on for 10 years, that's the deal we made. So no, Tom, that's not the case. So what was the issue? Again, I got caught off when I saw that. I need to answer Tom. But what was that you just ended with, Brian?
Oh, that at the end of the day, we're going to have, when we get the discovery, we're going to be able to use those answers to get our people, our clients, on an equal footing with the people who got the exemptions. That wins us the equal protection claim. And then
here's an interesting one for you, and that's where I wanted to go with that, Brian, on equal protection. And I talked to a gentleman the other day that's actually in our case. I'm not going to give his name anyway, even if I remembered it. I got it written down in my notes. He is actually someone who is licensed and certified to train law enforcement and retired law enforcement in order to get the training that they need in order to be certified that qualifies them to be able to buy these weapons, right? This man trains them, but yet he does not fit a classification of being able to retain his weapons. He's out. He can't get them, but he's training them to the point that training is adequate for them. Is that it? That's completely ridiculous.
Yeah. And I think that's why we win.
Okay. Yeah, guys. So I don't have anything else. No, Mike, that FOIA information wouldn't be necessary. You can FOIA it if you want. It doesn't apply to the case. It's not at this point. So, citizens can send all the FOIAs they want. It's not something we can use in our cases. So it has to be the discovery that we gather through the case that we use that way. So that's the update, you guys. I hope that helps. Somebody asked about the restraining order that's in place. That restraining order is going to stay in place until some further issue by the Supreme Court, and what that might be, May, June, So yeah, anytime in the near future, the restraining order is still in place, the injunction, and all of the people that are parties to this case are not, they're not bound by the law. I mean, Illinois State Police even put out their guidance that even acknowledges that the people in our case are not bound by this law. You can't say the same for the Macon County case, but for ours, it's fine. So, I don't think there's anything else over there. Okay, you got anything else, Brian?
No, I think you covered it.
All right, everybody, we appreciate it. Have a good day, and we'll talk to you later.